Dated the 12th of January 2026, in which application we are seeking that the said suspected respondents be remanded at Capitol Hill Police Station and any application within the Republic of Kenya for a period of 21 days to enable the applicant, being the independent policing as a authority, to conclude investigations. We will also be seeking that the mobile phone be seized from the respondents, that the mobile phone seized from the respondents be subjected to forensic examination. This application is supported by an affidavit. One Abdirahman. We note that Article 49(1)(g) allows for the pre-charge detention if the said suspects are informed of the reason for the continued detention. We note that we have served the said respondents with application indicating that we are seeking for the said custodial orders. We support this Your Honor in the case of Betty Genutai Kimeiwa versus Republic 2018 EKLR. Your Honor, we further submit that the said accused persons are police officers who hold positions of authority and influence. As such, Your Honor, we foresee the risk of interference, not only with investigations, but also with the witnesses hearing. As such, Your Honor, it would be in the interest of justice to have the said accused persons remanded at Capitol Hill Police Station for the said 21 days to enable the conclusion of the investigations. Your Honor, we support this with the case of Republic versus Frederick Oleleliman and 4 others. Whereby the court held that in instances where interference may occur, the court has to determine whether the integrity of the criminal process and the evidence that will be presented by attaching stringent terms to the bond or bail terms, or whether they may not be guaranteed, in which case the court may find that it is necessary to subject the accused person to pre-trial detention. Having given the specific and justifiable reasons in support of our application, we really humbly pray that our application be granted and the applicant be granted the requested 21 days.
We can book it ourselves with the announcement by the prosecution. And we humbly pray for the 21 days that we have made in our application. Kind of submit.
It's my request upon this court that we are police officers and we don't have any intention of interfering in any matter. We are cooperating with the court, the investigators. So that's why I see no reason for detained for 21 days. We are very much available, very much around, and at any moment we are required, we shall avail ourselves for any action.
CPC Patrick Mtunga.
Natumia Kiswahili. Naomba tuwe released bad days. Tuwe nje, tunainterfere na any. Tutakuwa within, ukitana, tutaitika.
The court has considered the application by the prosecution and the reasons advanced for wanting both respondents detained at Capitol Hill Police Station for a period of 21 days. I have also considered the sentiments of the respondents who aver that as police officers, they will cooperate with the investigations and will not interfere in any way. Indeed, under Article 49 of the Constitution, it gives the court the discretion to order for pre-trial detention where there are justifiable reasons. In this particular case, it is alleged that the respondents, who are police officers, were involved in a fatal shooting of one Shukri Adan Ibrahim, which has led to public outrage and demonstrations, and therefore even their security is not guaranteed. Further, the respondents, being police officers, by virtue of their position, the likelihood of interference with the witnesses and investigations cannot be said to be far-fetched. I therefore believe the application by the prosecution to have the respondents detained is reasonable to enable the completion of the investigation. The court will, however, grant the applicant 14 days to conduct the investigations. In the said period, both respondents will remain remanded at Capitol Hill Police Station. We can have the matter mentioned on the 26th of January to confirm the status of the investigations and for the court to give further directions.